present for you guys today will be useful not just to you, but hopefully for your stakeholders as well. So I'm hoping that this is something that you really get some benefit out of. And, sadly, this is something that JC and I have dealt with a lot over the past 2 years. The pandemic has triggered a lot of estate issues for people, whether it was simply accelerating how their, transition of their assets was going to occur, or if it caught people completely off guard. I mean, I have driven to hospitals and handed estate packages to people through emergency room doors and FaceTime people through executing it right before they knew they were about to have to go to their intubation procedure. So, I mean, this has been tough. But the thing about all of this that we're going to talk about today is plan before the need. I think that's just absolutely critical. If you can actually have something in place before you need it, that puts you in so much of a better position. And this is stuff that affects people that have multi-million-dollar estates and people that have, maybe their last check bouncing when they cash it before they pass away. So it really affects everyone, large and small, in terms of their assets as well. As we talk about heirs property and kind of about how property transfers from one generation to the next, one thing I always like to do is show folks this. This is a table of consanguinity, which is a huge Scrabble word. I don't know if it'll show up in your Wordle or anything, but consanguinity simply means with the blood. In other words, this shows how you're related to people. So if you ever wanted to know what made someone a second cousin versus being a first cousin once removed, all you got to do is look at this chart. This chart shows the degrees of relationship to a person. So for example, you're a first degree relative of your parents, you're a first degree relative of your children, you're a second degree relative of your grandparents, of your brothers and sisters, and of your grandchildren. You're a third degree relative to your aunts and uncles, your nephews and nieces, your great grandchildren, et cetera, et cetera, et cetera. So number one, just take this to your next family reunion, you'll be able to figure something out. But the reason that I show you this today in the context of our topic is that if we don't have any sort of plan in place, if there's not a will, a trust, a transfer on death deed, a joint tenancy, there's just no other tool to make an asset move from the person who owned it to the person who's receiving it after their death. We rely on things like this table and statutes that we call the Intestate Succession statutes to figure out how we divide your stuff up. And what we always do is start with people that are the closest relatives. So if there are children, okay. If there aren't children, are there parents? If there's neither children nor parents, are there brothers and sisters, and so on and so on. And you keep working your way out through those degrees of relationship. So that's one of the critical things is if you don't have a plan in place, what does happen to your stuff? That's what we're going to talk about and kind of how we go through that chart that you see in front of you to make that kind of stuff happen. Now, as we're going to talk about heirs property, intestate succession, and having a will, all that other kind of fun stuff, you need to understand there are basically 3 pathways for property to get from someone after they've passed to the people who are going to receive it. Testate succession, which is another one of those fancy Scrabble words, simply means the person had a will. Okay, they died testate. In other words, they had a last will and testament. So that's where that comes from, right? So one pathway is through a will and the probate procedure. Another pathway is what we call intestate succession, someone who died without a will, without a testament. And those are a set of default statutes that says, okay, if this person had no other tools for transferring their property, we'll use these default rules for dividing that property up and settling the title. If you don't need any other motivation to have some sort of plan in place, then just think about it this way. If you don't have a plan or any other tools in place, your estate plan was written for you by the Oklahoma State Legislature. So just let that sink in for a while and see if that scares you into doing something. But then we have what are called will substitutes. And this is basically anything that's not a will or not the intestate procedure. And there are tons of will substitutes. Some of the most common ones that you would think of are having a trust, using beneficiary designations on your retirement accounts, having a transfer on death deed, a joint tenancy in your property, those kinds of tools that are either contractual or property title tools that transfer property after you die without the operation of probate or one of the other tools that we talked about there. Okay, well, when someone passes away, what happens? And an important concept for everyone to kind of bear in mind is that something has to legally act on every piece of property you have to transfer its ownership after you die. your property is not going to pick itself up and take itself and transfer its title to somebody else after you die. Some external legal force has to act on it. And once you understand that, then you kind of understand, okay, now I get why there needs to be a will or a trust or a title or something like that that transfers that property when we die. So when someone dies, if they have a will, then that will goes into probate in the district court where they were domiciled. Domiciled just simply means where they were, principally living at the time that they passed away. If they had more than one home, where did they regard as being their true home? But that will has to go through the probate process. If that person didn't have a will, then we would go through the intestate process. A relative of that person would have to go to that district court and say, Your Honor, we've searched through everything. We can't find any evidence that this person ever had a will. We have not been able to find a will. We are needing to assume that this person didn't have a will, so we can go about handling the disposition of their property. Now, note, this is kind of an important first step. Lots of people say, well, I know that mom and dad willed me that piece of property after they die. So, I mean, it's mine. It's just a matter of time. And that's not how that works. People skip the step one all the time and just assume that if they've been given something in a will or a trust or something like that, but that person hasn't died yet, it's already theirs. And that is just simply not the case. And lots of people get themselves into lots of problems doing that. Once we've started that process, then we have to pick a person. A human being has to administer this estate. So we call that administration if there's no will, or execution, the executor of the will. If there was a will, they have to inventory everything that person owned at the time they passed away. They have to determine all the debtors and creditors of the estate. This is another thing that I see people miss or make mistaken assumptions about all the time. Your debts don't die with you. Your debts at the time that you died have to be handled in some way, and they have to be handled out of the assets remaining in your estate. So one critical thing I think people don't think about is, what property are you willing to have liquidated to cover those debts if they're still out there? Do you have insurance coverages that would take care of those things? So think about how those debts would be handled. Now, the person that's managing this property has to maintain it until we can complete this process. So if our average probate in Oklahoma takes around a year, and that's kind of being generous. Many probates take longer than that. And we've given someone a farm asset. Is our executor going to be capable of managing a farm for a year until that can be handled? You need to make sure that the people that you put in charge of handling your property after you pass away have the tools, the ability, or at least access to people who would have the ability to help them manage those assets, because you've got to make sure that you preserve the value of the estate until you can get it in the hands of the people that are supposed to receive it. But you don't have to grow it, reinvest it. You basically just have to preserve it. Now, step 3 is where we send notice to all of our creditors. Creditors make their claims against the estate, and then we pay those claims off. Again, we may have been given guidance, or we may not have been, about which property we're going to sell to make that happen. And once we've taken care of all of that, then you submit a final inventory and an accounting. This is essentially an audit of the estate, so that the executor or the administrator can show, here's the property this person owned when they died. Here are the debts that they left. I've paid those debts. Here are the other transactions I've made to maintain the estate. Here's what's left. This is to show that the executor hasn't done anything wrong, that everything is there, nothing went missing, no fraud has occurred, and that the people that are receiving the property are getting what they are indeed entitled to, whether it's under the intestate statutes or under the provisions of the will. And once that's done, you can close the probate and the estate is finished and everybody kind of moves on. So these steps that I just outlined for you, that's what happens when we are using a will or the intestate succession statutes. I mentioned there are will substitutes. Will substitutes don't follow these steps. For example, if you have a beneficiary designation on your retirement account, then once someone has died, that beneficiary can go to the holder of that account, provide the proof of death, provide proof that they are the named beneficiary, and then that account simply gets transferred to them. With a joint tenancy piece of property, and let's say 2 spouses own a piece of property in joint tenancy. The surviving spouse would go to the county clerk's office, provide the death certificate as proof of death for the other joint tenant, provide proof of their identity, and then the property can be transferred to them. So it's a much faster process with those substitutes, and that's why lots of people really like the substitutes. But what if you don't have a will? Really, we've outlined the procedure in the past few slides, but what we're talking about here is who gets what under the will. So there are just charts and charts and pages in the Intestate Succession Statutes about all of the different scenarios about a person who dies without a surviving spouse. So what if a person dies with a surviving spouse and children? What if a person dies with a surviving spouse and siblings, but no parents, no children, blah, 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 blah. It'll blow your mind. That's why, by the way, the slides that JC and I are presenting to you today are a summary of what would be 15 credit hours of courses in law school. So we're condensing things down a little bit. Well, let's just talk about a couple scenarios real fast. Let's say the person who died, by the way, the decedent or the deceased, has a surviving spouse and kids, and their kids are kids also of the surviving spouse. In other words, these aren't stepkids, these aren't kids from a previous marriage. It's simply this person's been married once. All of their kids are kids also of the surviving spouse. Well, in that case, the spouse gets half of everything and the kids get half of everything, which you might think to yourself, great, okay, no problem there. But what if your surviving kids are over the age of 18? They're entitled to receive that property and just take it and run with it. And maybe as an 18-year-old, you were super responsible and would only make prudent investment decisions if you got a lot of inherited money, but some 18-year-olds might not. But that would also mean that the surviving spouse is left with only half of the estate for their support. Maybe it's not a big deal. Maybe the spouse has significant, income from their job and doesn't really need the income productivity of the asset base, but they might. So you can see there can be some real problems there. But let's kick things up another notch and say that there's a person that's been remarried and that they have kids that are not also the kids of the surviving spouse. Now we have to divide joint industry, or what you might call marital property. That's property that both parties acquired while they were married. That gets divided up in half, with the surviving spouse getting half of it and the person who died's kids getting the other half. Non-joint industry stuff is basically share and share alike with that surviving spouse and the kids of the person that passed away. So let's say that Mike married Carol, and Mike had 3 kids from a previous marriage, Greg, Peter, and Bobby. Carol has 3 daughters from a previous marriage, Marcia, Jane, and Cindy. And of course, they have a maid, Alice, so somebody who's worked for them for a while. Mike dies, doesn't have a will. Well, who gets what? Well, remember the rules that we just talked about. We take the stuff that Mike acquired with Carol while they were married. All that stuff gets divided up one way. And then there's another bucket of property. That's the stuff that Mike brought to the marriage, but that he didn't acquire while he was married. And remember these rules. Spouse gets half of the joint stuff. The decedent's descendants, so Mike's kids, divide up the other half. So Carol's going to get half of that, or 50% of the joint industry stuff. Greg, Peter, and Bobby each get a third of the other half. In other words, they each get a sixth there. And then for the non-joint stuff, Carol gets a quarter, and each of the boys get a quarter because there are 4 of them, share and share alike. That's kind of confusing. Let's put this in graphic form here. So just with one guy, with Mike passing away, the stuff that he acquired with Carol, Carol gets half of, not all of, half of. If we're just assuming that this wasn't joint tenancy property or anything else like that. His kids share the other half. Stuff that he acquired before he got married is share and share alike with the other kids. And you start to see we are breaking up property left and right here. Unless Mike and Carol were proactive, and let's say, for example, they put the bulk of their farm into a joint tenancy with right of survivorship. If that was the case, then when Mike died, all of the property that was in joint tenancy with Carol would transfer to her, maintaining the integrity of that asset base, and you wouldn't have a lot of people sharing in these undivided interests that we have here in this scenario. But if he wasn't proactive about that, it's pretty easy to see that really fast you start to fractionalize this property. That decreases its value. It makes its management harder because now we have multiple people that we have to get to agree to on things like expenditures, maintenance, and all those sorts of things. And what if these people just really don't like each other? I mean, it's possible that you might have a really great relationship with your stepmom or your stepkids, but we all know situations where there are pretty rough relationships between, step parents and stepkids. And forget that, between brothers and sisters and moms and dads. You probably don't want to put property into joint ownership with people who can't stand to be in the same room because they probably don't really enjoy being in business together either. So what if you've been given a big chunk of property that has multiple owners and it's just hard to operate that property profitably, or you just flat out don't want to hang out with these people? Well, if you want out of a joint tenancy situation or a tenancy in common situation where multiple people have co-ownership of this property, you can apply to the court for partition. Partition is simply a procedure for breaking up people that are in co-tenancy, whether it's joint tenancy or tenancy in common. And there are voluntary ways of doing this. You can agree amongst yourselves to just sell out to the other owners. I mean, and all things being equal, that's probably the fastest, most efficient and easy way. But sometimes it just doesn't work out for whatever reason. So another option that you have is to physically divide the property. When we hear that two people own property as joint tenants or as tenants in common, sometimes in our head we say, okay, well, that must mean that, like, for example, Shannon has a quarter section of land with his brother Nathan. They have half interests. Okay, well, Shannon must hang out on the east half and Nathan hangs out on the west half, or Shannon hangs out on the north and Nathan hangs out on the south, right? But that's not how it works. An undivided interest means you have access, title to the entire property. So when we physically partition property, what we are really doing is breaking that piece of property into physical parts. This part now belongs to Shannon. That part now belongs to Nathan. They don't have co-ownership. We've basically have the property either in terms of value or just simply in terms of area to come up with Shannon owning this 80 acres and Nathan owning that 80 acres. You could sell to a third party and just basically realize the revenue from that in your proportion. So if Shannon and Nathan sell their property and they're 1/2 owners, well, then Shannon gets 1/2 and Nathan gets 1/2. But if you can't agree to do this voluntarily, then you can go to the local court, the district court for the county in which the property is located, and ask for a court-ordered partition. Now, when that happens, the court's first desire under the statute is to try to physically divide the property, like we just talked about. So Shannon, you get the north half, Nathan, you get the south half, or whatever the case might be. And odds are, as we're going to talk about here in a second, it probably doesn't work out to be even halves, right? But we're trying to physically divide this property in such a way that the parties get roughly equal value. If that doesn't work, and we'll explain why that's pretty hard here in just a second, then the next option for the court is to have the property appraised. And then the court will say to the parties, all right, this property is worth $320,000. You guys want to buy it? Does someone want to buy it here? If so, great. Or we'll sell it and divide it amongst you. And if that doesn't work, then we take it to auction and then just divide the proceeds equally amongst the people in terms of their pro rata fractions. But remember, this is usually the option that we wind up with because it's just hard to pull off the other two. Why? Well, let's say that we've got this quarter section of land, and let's say there's 4 co-tenants. Let's say that's 4 kids that got this property in undivided interest. And let's say the fair market value of this property is $480,000. So we could just go sell this thing at public auction and 4 people split up $480,000, which, that might be fine for them if they don't have an interest in actually possessing the land themselves. But what if they say, no, we don't want to do that. We know that mom and dad wanted us to retain ownership of this. We just need to divide this thing up in 4 quarters and we'll all get equal value. But what if your property looks like this? What if you've got these 4 quarters, right? This 160 acres. And on one of the quarters sits the family homestead where your family has lived for 5, 6, 7 generations. You've got another quarter that has a pretty nice lake or pond on it. That's got good water access for livestock. It might have a pretty high recreational value. You've got another quarter where the productivity of the land, it may be kind of marginal, but it's got some excellent wildlife habitat. It's great for deer hunting. And those rich lawyers from Oklahoma City would pay you a lot of money to go deer hunting there. Then you have another quarter that just has the richest, most productive soils. It's a fantastic, piece of land for cultivating actively cultivated crops. And by the way, the west side of this property has direct access to a nice paved public highway. The east side is completely landlocked. Now, how do you go about equally proportioning this land amongst 4 people? It's a lot tougher than you might really think, right? Because there are so many different factors at play that influence the value of this property. That's what makes physical partition so hard, and it's why so many pieces of property that are going through the partition process wind up just being sold at auction and the proceeds being divided up amongst the surviving co-tenants there. Well, how do you avoid that? Like we said, the key to that is planning before the need. So here's what I'm going to tell every single man, woman, and child that I run into that they need to have in terms of their estate planning documents. Everybody needs to have a will. And I don't care how much property you have or how little property you have, you need to have a will. Everybody needs to have durable powers of attorney. Those are authorizations for someone else to take care of you if you become incapacitated. And one thing that we have seen just rampantly during the pandemic is people having to go on an intubation procedure where they're on a respirator, and as a result of that necessarily have to be unconscious. Well, they obviously cannot communicate. They obviously cannot contemplate their business decisions. So you need someone to be able to take care of your affairs for you. And we can also divide that power of attorney between someone who is taking care of your business affairs, so handling property, paying bills, et cetera, and also someone who's able to make healthcare decisions for you. And we'll talk about this a little bit more later on. Everybody needs to have an advance directive for healthcare. That's basically you specifying what you want to have in terms of end-of-life care. And again, unfortunately, during the pandemic, these have become hugely important for so many people. If you have kids under the age of 18, you need to have a guardian nomination for those children. Who gets custody of those kids if something happens to both of their parents until they're 18? Beneficiary designations. If you have a retirement account, if you have something like a 401k, a traditional IRA, Roth IRA, any of those kinds of accounts, many bank accounts and other kinds of savings vehicles will allow you to specify who receives title to that asset after you die. Incredibly effective tool. It works very quickly. This cannot be overstated how good of a tool that is. So if you have any ability to designate a beneficiary on any of your accounts, do it and check them every once in a while. If you've had a new kid born, if you've been remarried, if you've gotten divorced, anytime you have a major life event, go back and check to make sure those beneficiary designations have been brought up to date. And I apologize, my animations got off just a little bit here. For lots of people, term life insurance might be a really powerful tool if you are going to lose an income to a family that family is really dependent on. If you have some pretty substantial debts, for example, if you just acquired some new property or equipment, or just have a pretty big mortgage or student debt, and it would make the financial life of your surviving family a lot easier if that debt was just gone, then look at maybe using some term life insurance to do that. If you're a relatively young, relatively healthy person, term insurance is pretty cheap for what it does. So it may be a really important tool for you. And then for people that have a pretty significant amount of assets, a trust can start to be a pretty important tool for making sure that that property gets transferred quickly to the parties that it needs to go to. Or if you want to retain ownership, which I know you can't retain ownership, you're dead. But if you want the ownership integrity of that property to be kept together for a while, a trust may be one tool of doing that. Now, if you have a will, and here's why LegalZoom or some of the other website forums can really get you in trouble. Even if you've gone to the trouble to execute what you think is a really good will for yourself, you have to follow the requirements for it to be validly executed. First off, it's got to be in writing. Audio recordings, video recordings don't work. It has to be in writing. It has to be signed by the person making out the will, or if they can't sign, someone acting on their behalf to help them sign it. It has to be signed in the presence of 2 witnesses, and those 2 witnesses have to be people who aren't getting property under the will. This is hugely important. If a person witnesses the signing of the will and signs as a witness, they could be disinheriting themselves, basically. I'm oversimplifying a little bit here, but you want two people who are not getting anything under the will to be the people that sign you as witnesses saying that they saw you voluntarily sign the will. Then you have to acknowledge, hey, this is my will, and the witnesses have to sign. So make sure you do all of that. Real quickly, we're going to talk about codicils. Codicils is simply a fancy word for amending your will, and it has all the same requirements, logically, that you would have if you signed the will. But all that to say is if you make a will and you need to change one or two things, you don't want to necessarily redraft the whole thing, but there's one thing you want to change, there's one specific piece of property that you want to go to a person that you didn't think about before, then you can amend it using a codicil without having to redraft the entire will. Note that anything that you don't change in the will is considered to be reaffirmed once you enact a codicil. So let's say you executed a will, then you got divorced. Under Oklahoma law, a divorced spouse is considered to be automatically excluded from a person's will. But then you execute a codicil and you don't mention that you got divorced. Well, now you've basically reaffirmed the rest of the will and pulled your divorced spouse back into the will. Most people don't like doing that, okay? So be careful about your codicil. Make sure you check over the whole will. But you can also say like, hey, if I've acquired a few new pieces of property, we can incorporate a list of those properties and who receives them by reference by the codicil. So pros and cons of wills. With a will, you have absolute control over your property until you die because you can amend your will anytime until you die, as long as you have what we call testamentary capacity. Testamentary capacity means that you have the mental ability to understand what you're doing, what you own, who your family is, and how all those things work together to transfer property to those people after you die. Again, during the pandemic, when people have had lots of respiratory problems and have seriously had oxygen deprivation, capacity is a huge issue, and sometimes that illness progresses really fast. You want to execute your will when you are at the peak of health, okay? I can't stress that enough. Don't wait until you say, well, once I'm feeling pretty ill, then I'll get it. No, it's too late. You've got to do this when you are feeling absolutely fantastic and really focused. You can tell your property where to go, and that can be anywhere. If you want it to go to your kids, great. If you want it to go to a charity, great. If you want it to go to a friend, great. You can say wherever you want it to go. You can pick the executor, meaning the person who's going to be responsible for this. Talk to that person. Make sure that they're comfortable doing that. They may not have the skills, they may not have the disposition to deal with what may be a pretty contentious relationship amongst the surviving family members. They might not have the time. Being an executor is a full to part-time job, just depending on how complex the estate is. So just make sure that you talk to your executor and they're okay with it. And you can name guardians for your minor children in your will. You can do that as a separate document. We talked about that with the guardian nomination, but you can also reaffirm that in your will. Now, on the downside, wills have to go through probate. It's a process that takes time. It takes money. There are certain deadlines that you basically have to hold open, for example, for creditor claims. And so that means that a will basically has to take at least 6 months if it's going flawlessly to be fully conducted through the probate process. More often than not, it's going to take a year at least, probably more like 2 years in many cases. Wills can be contested. If I don't like what I got under the will, I'm basically just going to say, this person didn't have the mental capacity to execute this will, or the witnesses were influenced, or something. But there's lots of things I can do to kind of try to attack some of the weaknesses in a will. Doesn't mean that they're successful, but it will slow down the process. All of this is public. Your will, your inventory, your accounting, all of those things get put into the court record. They're part of the public process. So the public can see what's going on there. If they want to see your inventory, it's an open record. You can't really seal that. It's also state specific, meaning if I owned property in Oklahoma, Texas, and Kansas, and I lived in Oklahoma, well, my will would have to go through probate in Oklahoma. Then we would have to submit that will and that ruling to the courts in Texas and do the same thing in Kansas, because Oklahoma courts only have jurisdiction over Oklahoma property. Same thing for Texas, Kansas, and any other state of the union. So if we've got property that's held in other states, we'd have to probate that in other states as well. Wills are very good tools, but these are some of the challenges that you do have with them. So I just want you to be aware of that. We'll talk about durable powers of attorney real quickly. Like we said, these are giving other people the power to take care of your affairs for you. I say durable a lot because if you want someone to be capable of handling your affairs while you're incapacitated, we have to specify that that power is durable, so that it still works while you're incapacitated. You might also want that power to be springing. What a springing power is, that is a power that is only effective when we're incapacitated. In other words, it's dormant until we become incapacitated, but once we become incapacitated, then that power springs into activity, and that person can take care of our affairs until we regain our capacity, and then it goes back away. The healthcare power, like we talked about, is different from the business power. That means that someone has the ability to make healthcare decisions for us, and that can be hugely important because if we don't have someone designated with that power, we've really kind of tied the hands of our healthcare providers in determining what they can do for us. So make sure you talk to both your business power of attorney holder and your healthcare power of attorney holder. Make sure that they understand what your desires and wishes are and give them the ability to make those good decisions for you if it comes to it. The advanced directive for healthcare is, like we talked about earlier, simply a set of instructions for what kind of end-of-life care you might want. And Oklahoma's got a lot of flexibility in their advanced directives. You can specify different instructions for different situations. For example, if you have a terminal illness versus if you have an illness which shows that you have no brain activity for a prolonged period of time, or if you just have a persistent illness that's never going to get any better with current medical technology, you can specify, do you want to have CPR? Do you want to have artificial respiration? Do you want to have artificial nutrition and hydration? You can also execute a advanced directive with separate instructions for dealing with dementia issues, specifically an issue for people with Alzheimer's or other mentally debilitating diseases. But you can say, if I reach a certain level of functionality, that's when I want to trigger this advanced directive, and here's the kind of care that I want. Here's the kind of care that I want withheld if I would like to pass, sooner rather than later. We've already talked about guardian nominations for minor children. Just real quickly again, remember, if you've got somebody under the age of 18, you can specify who gets custody of them. It's not in Oklahoma regarded as a legally binding order, but I will tell you that in Oklahoma, our courts give very significant deference to that guardian nomination. Basically, unless something just seems like it's going to be completely against the best interest of the kids involved, the court will say that's the guardian nomination. That's who we're going to regard as receiving custody, unless we can see very clear and convincing evidence that custody shouldn't be given there. And really, the whole point of this is to avoid a really nasty custody dispute, which unfortunately I have seen happen. And that's just the last thing that you want in those circumstances. Beneficiary designations, again, we're specifying simply who receives custody of this account on the death of the account holder. Operates very quickly, very efficiently. It's just a phenomenal tool. Do not overlook your beneficiary designations. Anytime something major happens in life, make sure you check those designations and that they are what you want them to be. When I was a single person, I picked my favorite charity and made them my beneficiary designations. And after I got married, you better believe I changed my beneficiary designations to my spouse, because that would have been super awkward otherwise. We've kind of talked about trusts a little bit. Trust is simply a means of holding property in a separate entity. Think of it kind of like a mini corporation that you might still be in charge of, but you might create a revocable living trust, and that trust holds property. Then immediately after you die, a new trustee is appointed, and that trustee can distribute the property however you would like to have that happen. Life insurance is a tool that simply provides a payment to a designated beneficiary or beneficiaries after the person dies. Life insurance can be a pretty important tool. For some people, life insurance isn't necessary. Folks that are perhaps older, in a really good equity position, really no outstanding debt to speak of, life insurance may not be a big deal, may be, kind of pointless for them. But for younger people, maybe heavily leveraged, significant debt, life insurance might make life a lot easier for the people that come after them. Just talk to a good financial professional who's not selling you life insurance, because if they're selling it, they're obviously going to think it's amazing for you. So talk to an objective person that's not selling life insurance and kind of figure out if that's the tool that you need, and if so, what kind of life insurance do you need and in what amount. With payable on death accounts, that's kind of a beneficiary designation on a bank account. A payable on death provision simply says when this person dies, take the contents of this bank account, pay them to this person. I want you to understand that's very different from making someone a joint account holder. If someone is a joint account holder, they have basically a co-tenancy in the account with you. If that person has a bankruptcy or debt collection issues, your account is at risk, because that's a joint asset of the two of you. That's an asset that could be seized by the bankruptcy estate. It can be seized by creditors. And so that's an important distinction to make. There's a big difference between making someone a joint holder and making someone a payable on death beneficiary. I'll add a third distinction here. Making someone a signatory on your account is different from both of these things. Simply giving someone signature authority means that person can sign checks on that checking account, for example. So if we want someone to be able to pay bills on our behalf, we might make them a signatory, but not a joint account holder and not a payable on death beneficiary either. Joint tenancies, we've kind of already talked about. For example, a joint tenancy with right of survivorship is probably the most common joint tenancy that we see people voluntarily put together. And that simply specifies that if we have two joint tenants, when one of the joint tenants passes away, full ownership of the property vests in that surviving joint tenant. So the most frequent case you would see that would be with spouses. For example, my wife and I own our home as joint tenants with right of survivorship. If one of us should pass away, full ownership of that property would then vest entirely in us. Well, let's talk about trusts real quickly. We've got about 5 minutes here before I need to kick things over to JC. But like we talked about, a trust is basically a separate entity that we establish to own property and manage that property. Now, it can be very simple or very complex. It just simply depends on what we want to do. Some people say, the only reason that I want a trust is to avoid having to go through the probate process. So I'm going to put the property in the trust. When I die, trust, distribute this property to these people, and then you're done. Wrap it up, dissolve, move on with life. Okay, pretty easy. But if I want my trust to maintain ownership of this farmland for the next 2 generations, and I want to specify that this can be done with the income and this can be done with the principal, and et cetera, et cetera, et cetera, well, it's a lot more complex, and our trust has to be a lot more complex to carry out those instructions. That's just it. A trust with simple goals can be very simple. A trust with complex goals probably needs to be more complex. Now, in a trust, you're going to have the trustor. That's the person who puts property into the trust. A trustee, the person who manages the property that's there. And beneficiaries, which are the people that receive either income or property, or in some cases, maybe both, out of the trust. And it's entirely possible that if we establish a revocable living trust, which is what a lot of people do as an estate planning tool, they're the trustor. They put the property in the trust. They're the trustee. They manage the property in the trust, and they're the beneficiary. They receive the income from the trust. But then when they die, new people step into the trustee and beneficiary roles. The most common type of trust that we probably see is a living, or you might call that an inter vivos trust. It's simply a trust that we establish while we're alive. Most of those are revocable, meaning if at some point we decided we don't want to have a trust anymore, we just want to pull all the property back to ourselves and not mess with it, then that's a revocable trust. Some people create irrevocable trusts for estate tax management purposes. JC will talk about that here in just a second. Or if they're trying to manage Medicare or Medicaid eligibility, they might use an irrevocable trust. There's also a testamentary trust, and that is simply a trust that is established as part of our will. Things you need to think about: who's the trustee? Who do we want to put in charge of managing the property in the trust after we're gone? Talk to that person, make sure that they have the skills, the temperament, the attitude, and the time that they need to carry out that job. Now, lots of people say, well, I've got 3 kids and I love all 3 of my kids equally. I don't want them to think I'm being partial to any one of them. So I'm going to make all three of them co-trustees. As an attorney for 19 years, I'm going to tell you that's a terrible idea. You need to have one trustee at a time. Making more and more co-trustees just creates more opportunity for deadlock and decision problems. However, I'm a big fan of successor trustees, which means I want you to have a list at least 3 people deep. So if this person says, I can't do it, or for some reason they might predecease you, okay, then who's the next person up? Then who's the next person up? Think about who your beneficiaries are going to be. Is it all of your children? Is it all of your grandchildren? Does that include adopted parties? Who do you want to specify there? How long is the trust going to last? Do we want it to last just a little bit longer than us so it distributes property and then it's gone? Or do we want to keep it in place for as long as we possibly can to keep our farm assets together? What are the rights of the trustee? Can the trustee buy property? If there's a piece of land that we've always wanted to add to our operation and it becomes available after we die, do we want to have that added? And if so, we got to give the trustee the power to buy property. Do we need to give the trustee the power to mortgage property if we want to do that kind of thing? In Oklahoma, it's hugely important that we tell our trustee what we want to do in terms of leasing minerals and also executing wind and solar leases, because increasingly those are a huge issue. How do we want our trustee to invest revenues? Do we want them to be super conservative or just, relatively conservative? Do we want them to shoot for the moon and swing for the fences? And how do we want them to distribute trust income? On what kind of periodic basis, or in the event of certain life activities like a marriage or college or a first home or something like that? And in certain circumstances, do we want the trustee to just go ahead and actually distribute out property from the trust? And what can people do with that stuff once they get it? When are they going to get it? So having said all this stuff, trusts have some pretty significant pros and cons as well. On the pro side, it eliminates probate, right? Things go pretty quickly. I was helping administer one trust in this past year, and in roughly 6 months, the trustee was able to accomplish all the property distributions that they were instructed to accomplish under the trust. You don't have to have a guardian to hold assets for kids under the age of 18, and you can hold those assets for way longer. If you want that kid to get those assets when they're 30, and they've hopefully had a time to figure out life a little bit, you can hold it for longer if you want. Trusts don't have to be filed publicly, so they don't put that information out there. And trusts are a lot more difficult to contest than a will is. On the downside, you need to pay a trustee fee if you're having an outside trustee manage the trust. Let me talk about that very quickly. If you've got a pretty contentious family relationship there, and you're worried that if I name a family member a trustee, they're just going to be part of the fight, it might be worth paying the trustee fee to get a bank trust company or someone else outside the family to administer the trust for you. They have a higher degree of objectivity, and they don't care if the family hates them because they're just doing their job and they're getting paid for it. It does add a little bit of complexity. You still need to coordinate it with your other tools, and you do still need a will because it's possible that you might forget to put stuff into your trust. And if so, you need what we call a pour over will that rounds up any property that you may have forgotten to put into the trust and gets it there for you. So last thing I want to talk about real quickly again is the life insurance piece. All I'll tell you is talk to your financial professional. And again, if you have a financial situation where life insurance, and a cost benefit analysis is a really positive thing for you, it might be worth thinking about. It's not right for everyone, not right for every situation, but I've seen lots of families that could have benefited from a nicely calculated, right-sized amount of term life insurance that sure would have made things a lot easier on the survivors than they would have been otherwise. And with that, you hear that digging in the background. That's my time. I need to turn things over to JC. If you thought estate administration, partition, and all that stuff was fun, wait till JC tells you about taxes.
Hey, thrill a minute. Hey, Sharon, they didn't even want to talk to you. No chat.
Nobody wants to talk to lawyers.
Except accountants. Shannon, can you see the screen?
I can.
Fantastic. Let's get started here. So, as Shannon laid out the estate transfer issues, property ownership issues, the tax issues They're there, but they're not, they have some opportunities here, but they really don't affect very many people under the current tax law. And I'll explain that in a moment. But there's some very unique things that have occurred in the last about 15 years. What you're looking at when it comes to the estate, the taxes of the estate, you've got the federal estate tax. It's still in place, it still applies. However, the Oklahoma estate tax, it was repealed, and that was made permanent effective January 1, 2010. So estates after that point in time do not have to worry about an Oklahoma estate tax. It's gone. A often misunderstood piece on estate taxes. As an inheritor, you have no estate tax. The estate tax is levied on the decedent's estate, not on the recipients of the assets. So when you receive an inheritance, it comes to you tax-free. So the estate taxes are on the decedent's estate. Now, when Shannon talked about some of the pieces, it takes a while to get the estate settled. A lot of times the estate tax piece causes it to drag out to that 9 months. Typically, it takes about 9 months to get an estate tax. That's the requirement. And depending upon what all is going on, it can sometimes take that full 9 months. So there is pretty much what we look at as one piece of that puzzle of how long it takes to settle an estate. Now, when it comes to how do we determine whether we ought to have a taxable estate, you're looking at the assets that we have that is owned by the decedent, and what is the tax basis of those? Now, the tax basis basically tells us that this is what we paid for it, or this is the value that we have should we have sold it. And when it gets into the estate, that is what's looked at as the potential for the estate tax return, because we're looking at how much the value of the estate has grown. So pieces of it, usually the purchase price. If we have land, it's going to be the purchase price and any value of improvements made. So if you've added terraces, that increases the value, usually above and beyond the cost of those terraces, adding ponds, etc. So your purchase price less the value of those improvements. It requires an appraisal, kind of get an idea of what the current value of it is versus what we purchase it for, to get an idea of the increase in the value. Machinery, purchase price, again, less any depreciation that was allowed. Now, when I say allowed, a lot of folks, and I've run into this frequently, they buy a piece of equipment, a farmer does, and they fail to put it on the depreciation schedule. Doesn't happen often, but it does happen. Then we find out that they didn't depreciate it. Tax rules say if it was allowed, it must have been taken. So you're going to look at the purchase price, less the depreciation that was either taken or allowed for the ownership of that. Gifts received. If you receive a gift to somebody, your parents, your aunt, uncle, whoever, grandparent, and it's cash, very simple. But if they give you stock, it's going to be the purchase price that the giver paid for that stock. That becomes the giver's basis. That becomes your basis because it's handed down to you. So when gifts are received, you got to look at what was there. So if they're giving you livestock, they're giving you stock, they're giving you anything other than cash, you have to look at what they gave for it. That becomes your basis. So when you sell it, then that is the tax base that you have to pay the tax upon the gain. So those are the big pieces of basis. It's very important to understand that, because what we end up with there is the determination of what was the value of the taxable estate.
Oh, JC, sorry to interrupt you. What we've got on our screen is your PowerPoint main screen, but not your slide presentation screen. You might just want to reshare to the screen where your slideshow's at. Sorry about that.
How in the world do I do that, sir?
So when you go to your menu for share screen, it should give you some options of which screens to share. And what you want is the one where your PowerPoint presentation slides are. Or if you want to on this screen, there you go. So now we have a full view of your glorious face. And so on your share screen, you'll want the one that where your presentation slideshow is. So now we've got your PowerPoint main screen. And if you just want to click through the slides here, everybody will be able to see what you got too.
Okay, so I need to back up a little bit.
Well, I can see, yeah, if you want to just click through your slides as you go through them like that. Yeah, there you go. And that'll be fine.
Okay, so this was the basis slide. Hopefully you saw that. So now let's get into the current law. Where do we stand as of January 1st of 2022? Now, a few years ago, we had a fairly low amount of estate tax exemption. The Tax Cuts and Jobs Act came into play and bumped that up. So currently, the estate tax exemption is $12,060,000 for every individual that has an estate. The maximum tax rate is 40%. It's applied to the amount of the estate that exceeds that 12.6 million fair market value. So if you look at this, and since we're looking at farms, and that's where Shannon and I primarily deal with, farmers and farms, operations, et cetera, that $12 million, excuse me, $12 million, there's less than 1% of our estates, farm estates, that are going to end up taxable, less than 1%. Currently, the number of US farms is just slightly above 2 million. So do the math on that. 1% of 2 million is not a very large number, and it's even less than 1%. So when we start talking about the estate tax, it's typically not a major player, but it's something to keep in mind. One of the things that often slips up on the farmer or the rancher is the value of minerals, mineral production, wind turbines, etc. Those increase the value. And a lot of times we look at the farmland, and we fail to think about those. But again, at 12 million per individual, not very often going to be hit. All assets receive a step up in basis, current fair market value at the date of the death of the decedent. So when my aunt passed away this past fall, everything that was in her estate was moved up to the date of death valuation as of November 1. So when my wife and I decided to sell something we inherited, we look back at the November 1 value, and that becomes the basis. And right now we could sell a lot of things that she gave us and not pay much income tax on that. Now, one thing about the exemption amount, it's inflation adjusted. So it goes up on an annual basis and it adjusted for the current inflation amount. So last year it was a little lower than right under 12 million this year. With the jump, we got it above the 12 million. Another piece that came into play was portability. Portability means that a husband and wife or spouses look at their estate tax exemption each, and if it's not used by one, it gets to be carried over to the second. So if you look at that for 2022, a couple can transfer an estate $24 million with no estate tax. Pretty sizable sum. So like I said, from the point of view of the estate tax, it hits very few people. One of the things required, though, when it comes to the portability rules, the surviving spouse or personal representative of the estate has to make the election to utilize any of that deceased spouse unused exemption. In other words, let's say mom passed away first. Her estate was worth $6 million. Now she's got a little over $6 million of estate tax exemption she didn't use. That goes now to the dad, the husband. And when he passes, let's say at the end of this year, he'll have a total of a little more than $18 million of estate tax exemption that can be applied to his estate. So with proper use, proper elections, that 12 million goes up to the 24,120,000. Again, you've got to look at all the pieces of that. It can really help reduce the amount of estate tax. So the estate tax, like I said, is not really a major player. Portability rule has to be elected on a timely filed estate tax return. That's usually within 9 months after date of death. Can get an extension on that, but it needs to be timely filed in order to make that work. So here's an example of how this really comes into play, even better detail than what I just gave you. So a husband passed away in 2017. The value of his estate was $5 million. Now in 2017, that was prior to the Tax Cuts and Jobs Act. So the exemption was $5.49 million. $5,490,000. So his unused exemption then was $490,000. Now we go to 2022. Current exemption is 12.6. The wife's estate in 2022 is 12.5. There was 490,000 left over. She can use 440,000 of her husband's unused exemption, avoiding estate tax. A great tool for wiping out, minimizing the estate tax problem. Like I said, it's not automatic. It has to be made by the executor or the surviving spouse, whoever's executing the will or making sure the trust is in place. Has to be done on a timely filed return. The unused amounts can be used to offset the future increase of the value of the estate when that surviving spouse passes. Or let's throw another kink in here. Lifetime taxable gifts. So if you decide after you receive or they have the property and they want to make some gifts to heirs, others, a taxable gift is anything above $16,000 currently. Taxable gifts, you don't pay the gift tax on it now. It passes through typically and offsets the estate tax exemption. Let me show you how that works here in a moment. But right now, here's where the rules state for taxable estates. Value of all property, allowable deductions. Those allowable deductions include a variety of different things. It's the funeral expenses, any debts, liabilities against the estate taxes, attorney's fees, etc. So that becomes the value of the taxable estate. So when Shannon was talking about the property, we're going to look at the total real estate, personal property, total value, date of death. If it's property owned in joint tenancy, if it's owned with between spouses, we don't worry too much about it. But if it's with a son or a daughter and the parent, you've got to look at how contribution was made. So let's look at the rules here. If it's a husband and wife, half of the value of that joint tenancy, in Shannon's case, he used his house, half of it's in his estate, half of it's in his wife's estate. If he owned a house with himself and his son only put $10,000 to the purchase of the house, and the house was worth, say, $200,000, the son's value is $10,000, Shannon's value is $190,000. So you've got to look at the contribution by both parties. If it's insurance, if it's owned and controlled by the decedent, it's in the estate. What I did when I got married, I changed my ownership of my life insurance policy. I moved it over to my wife. That way, when I passed, or if I passed, the full value was not in my estate because she owned it, she controlled it. She got was the beneficiary of the value upon my death. It doesn't go into the estate, it was never taxed. If I owned it and controlled it, it would have been in my estate for the full value of that. So something to think about. Taxable portion of gifts, like I said, are included in the tax base. So anything above the $16,000 currently would be input into that tax base of the gross value. If there's gift tax had been paid, then it comes back out. So it's not double counted in any way, shape, or form. So like I said, joint tenancy, half of the decedent estate, other than spouse, have to prove ownership. Property transferred to a revocable living trust. If that trust pays all the income to the decedent during their lifetime or at the direction of the decedent, it is treated as owned by that person, therefore it's in his estate. Now, Shannon didn't talk about powers of appointment. This is getting into a little bit more detail here, but if you have the right and you name somebody to control who receives your property, the person that has control and of distributing that is not considered as having ownership of it. He just has the power to determine where it goes and how it gets there. when we have assets that have grown in value, basis doesn't get increased. It can't be added to the asset. So other than a spouse 3 years prior to death, so we're looking at here is we do some planning. This is a very unique tool that's been done in the past. I'm going to cloud the waters a little bit with this. So you've got an uncle that's on his deathbed. Shannon has a piece of property worth a lot of money. He transfers it to his uncle on his death or prior to his deathbed, knowing that he's not going to live very long. Then he gets, the uncle passes after 3 years' time. It comes back to Shannon. He gets a step up in basis. If it happened within 3 years, there's no step up. So there's all kinds of ways to manipulate the estate tax law. And it takes some thinking. That's why it's always beneficial to talk to an attorney when we start playing with the idea of how do we want to make our estate transfer occur, will, trust, etc. So here's the federal estate tax, kind of give you an idea of what it said it grows. 2020, it was 11.5 million, a little over that. Then it went up to 11.7, 12.6 this year. Now, one of the things that we've got to watch out for, and right now, and you heard last year, there was a lot of discussion of changing, modifying the estate tax. Not sure that that's going to happen. But in 2026, January 1 of 2026, we have a sunset of the Tax Cuts and Jobs Act. It's going to revert back to looking at that 5 million exemption that existed then. So it's going to be cut in half. So if the 2022 value never gets adjusted up, in 2026, the estate tax exemption will be $6,030,000. So it's going to revert back unless something acts upon that between now and then. Now, marital gifts, you can transfer assets to a spouse. No estate tax, no gift tax applies to that. And that applies for both federal and Oklahoma. Now let's talk about those gifts a little bit more. So the gifts for 2022, $16,000 per person. Shannon is a very giving person. He decides to give everybody on this seminar today $16,000 tomorrow. He does not pay a gift tax on that. The recipient never pays tax on a gift received. If Shannon and his wife really feeling generous, they could use the gift splitting rules and give up to $32,000. They give 35 though, they reduce that unified credit that they have by $3,000. So that 12,060,000 gets dropped down to 12,057,000 for future use. Gift tax, return is just due April 15th, just like your normal income tax. Oklahoma, when they repealed the federal estate tax, they also repealed the gift tax. It's gone. So when you're looking at basis that you receive, this is a little different. Again, coming back, if you have it, gifts, it's recipient's basis, the same as that as the donor. So any gift tax that was paid does bump that up. Usually that's not the case. If it's inherited property, you look at the fair market value of the date of death, that's that stepped up basis. That's where you start when you receive it. So one thing to keep in mind, very important to realize, and I talk to folks every once in a while I've done this, no Oklahoma state tax and the 12.6 million exemption. They feel that they don't need to have an estate plan or do anything because there's no estate tax going to be levied. But right, there is no estate tax, but there is nothing there to trigger the movement of those assets from them to somebody else. So you still got to transfer those. Otherwise, they end up locked, or we got to go to probate. Then we probably don't have the transfer of those assets going to where we want them to go. Also, a federal estate tax return must be filed and get portability. So if it's below that 12.6 million, you definitely want to file the estate tax return. Make sure we get that portability in place. So we start talking about some of the things that we need to do. There's not one correct answer. Everybody's situation is different. Also, things changed. We know that right now we make an estate plan with a 12,060,000. When we get to 2026, we're going to really need to look at our plan to see if there's something else that we need to put into place so that we don't end up with a major problem. So the federal estate tax rules have to be thought through. If you do a good job of estate planning, you want to minimize those estate settlement costs. That's the attorney fees, probate costs, as well as the estate taxes. So with that, if anybody has any questions, I want to stop sharing. We'll go to the next piece.
You answered all of their questions about everything, I guess.
Either that or got so darn above them so fast it's not funny. Taxes are not simple.
Both are definitely possibilities. Okay, guys, I want to share with you some exciting new legislative work that we are in the process of trying to shepherd through the legislature this session. So as Shannon spoke about, we currently have tenancy in common here in Oklahoma. Let me move this so you guys can see. And so what that means is if an heir or if a person dies without a will or an estate plan, the land is equally divided, as Shannon was explaining. And then there can be a forced partition of sale, because we know not all families get along, and it can result in families losing some of their farmland, and generational wealth can also be affected. And so this fall, I worked with Representative Chris Canady and Representative Emily Virgin. They're both on the Judiciary Committee at the State House. And Representative Virgin was kind enough to file what we're calling the Oklahoma Farmland and Wealth Preservation Act. It's currently House Bill 3528 in this year's legislature. And what it provides, I'm going to send you guys these documents after the session. I know that Shannon and JC have already seen them, but I wanted to just go over a little bit with you guys what this kind of does, so you're familiar with it. I'll send you this sheet. This is just kind of a quick fact sheet about it, but the one I really wanted to talk to you guys about is this one. It has an example of heirs property, kind of like Shannon was talking about how things are divided out in that kind of very complicated pyramid. And so the solution, or what this bill allows us to do, is that the co-tenant requesting the partition is required to first notify all of the other co-tenants. So right now, they could notify them, or they could choose not to. If this piece of legislation were to pass, they would be required to notify all of the co-tenants. And then the court would have to give an independent appraisal of the land to determine a fair market value. So if any co-tenant were to object to this, they would hold a hearing to consider other evidence. So, because right now it can be difficult to divide property, let's say, especially if you may have a home on just one piece of the land. So if any co-tenant wants to buy the property from another co-tenant, they would have what they call the right of first refusal, which means they would have the first opportunity to purchase the land from the other co-tenant. They would also have 60 days to get their finances in order so that they could possibly be able to purchase the land from the other co-tenant. So they would have a respectable amount of time in which they would be notified, and then some time to kind of get their finances in order. If they don't want to purchase it, then the court would order a partition in kind, unless that they determine that will result in a greater prejudice to the co-tenant. So what that would mean is they would just need to consider whether or not that is appropriate in that case. And then what they would do is they would offer the property for sale on the open market and try to get a fair value for the land and for the property. so that it could then be equally divided. Because currently what can happen is somebody can come in and force a partition sale and maybe not offer a fair market value, and then the fellow co-tenants can lose some wealth that way. So we think that this piece of legislation is going to help families that maybe don't have an estate plan or don't have a will. Something that, like Shannon and JC spoke about, we've seen a lot last couple of years, especially with the pandemic and folks, passing away when they were not expecting to and at younger ages. And so we're very excited about this at OACD. I'm currently working on trying to get other folks to endorse the piece of legislation so that we can hopefully get it passed through the House and then the Senate. So far, we have had some great meetings with the Oklahoma Cattlemen's Association. We're meeting with Farm Bureau on Friday. I'm meeting with the Chickasaw Nation on Thursday. I've met with the Muskogee Nation, and then also have had some discussions with the Choctaw Nation. Langston University has endorsed it, and the Eastover Livestock Association has endorsed it, as well as OACD and, of course, the Oklahoma Black Historical Research Project. I'm working on getting OSU to endorse it. I'm hoping Shannon and JC can help me with that effort, but we'll continue to kind of build a coalition because we think that this is a piece of legislation that could be very beneficial to Oklahomans who are in this situation. So with that, I'm happy to answer any questions. And like I said, we will send over these materials to you guys as well. Are there any questions for Shannon or JC or myself?
And while we're waiting on questions to come in, thank you guys for the opportunity to visit with you about this. This is hugely important stuff to me and JC, and the more folks that we can equip with this information that can make good plans, the better off everybody is.
Absolutely. Thank you, Shannon, and thank you, JC.
Oh, sorry, Sarah, can I ask Shannon a question?
Yeah, absolutely, Bradley.
Okay. Shannon, if let's say a grandparent passed away, what is the ultimate position you can give a grandchild or something? Would the power of attorney enable that person, if the grandparent trusted them to do it fairly, totally disperse all of the assets and pay any bills or whatever without any problems, without a will? I mean, if there wasn't a will, but they wanted to give power of attorney to someone.
Oh, so let me ask a clarifying question, Bradley. Are you talking about before grandparent passes away or after?
Well, if the grandparent gave power of attorney to the grandchild and then she passed away, would that entitle that person who has power of attorney to disperse the assets? Or
Bradley, you have asked a phenomenal question, probably even more phenomenal than you realized. So here's an important distinction to make. A power of attorney evaporates immediately upon the passing of the person who authorized it. So I'll use myself as an example. Let's say my granny gave me a power of attorney while she was alive. Hey, Shannon, you seem like a remotely competent attorney. Pay my bills, take care of my affairs. You basically act like me for business proceedings while I'm still alive. Okay, so I can write checks, pay bills. And even in extreme cases, depending on how you wrote your power of attorney, I might have the power to make gifts of Granny's property if I felt that it made Granny better off as a result of that. Say, for example, we were worried about her Medicare and Medicaid eligibility. So I gifted away property to make her estate such that she would be eligible for Medicare and Medicaid coverage. I can do that while she's alive, but the moment she passes away, that power of attorney completely evaporates. It has no legal effect at all at the moment of that person's passing. The only way that I can have any sort of ability to dispose of property after someone passes away is if I'm named an executor of a will, administrator of an estate, or trustee of a trust. And an important thing to note, by the way, about each of those avenues, executor, administrator, trustee, every one of those has some form of instruction given to that person. If it's the executor, the instructions are the will. If it's administrator, it is the procedures of the Intestate Succession Statutes. If it's the trustee, then I have instructions as part of that trust. So I can have power to take care of somebody's property before they die, but after they die, I've got to be authorized by one of those other vehicles to make that happen. And I've got to have some form of instruction given to me about how to handle that. So that's an exceptional question. I'm glad you asked that.
Okay, thank you.
Answer it.
Thanks, I appreciate that.
Okay. Kevin, I see a hand up there.
Yes, I wanted to know, I guess it's a question for all of you. For someone who is just starting out to gain assets or wanting to gain assets, where would you suggest for them to start? Say me, I'm 33 and I'm just getting this information and wanting to make sure that my daughters and my next generations are taken care of. Where would I start?
Sarah, I think you stack the audience with ringers because these are fantastic questions. You know, Kevin, the first thing I would tell anybody to do, and I do tell everybody who's willing to listen to do, is start with your inventory. Sit down and do a really deep dive on everything that you've got. So, for example, any real property, if you have ownership of any real property, drag out the deeds. If you don't have the deeds, go down to the county courthouse and get the records from the deeds, because I want you to see, do you own it entirely in your own name? Do you own it in maybe joint tenancy with a spouse or in co-tenancy with another relative or something like that? But know how you own that property, get that deed so you have the legal description, get the titles to your vehicles, line up all of your financial account information in terms of account numbers, who's the institution that holds it, any beneficiary designations you've already filled out, any retirement account statements that you've got from your job. Just lay all that stuff out. Now, there's huge value in just that simple step. Number one, you're going to have to do that anyway, because if you go to an attorney or a tax professional and say, hey, I want to start doing some of my estate planning, they're going to turn you around, push you back out the door and say, great, go round up this inventory. Well, you've already done it. So you've saved yourself some time and money there. But number two, an important part of that is just the process. As you're pulling together all those pieces, you start thinking, okay, if I've got outstanding debts, let's say I've bought a farm, but I've had to mortgage it, which, you know, is the case for almost all of us, unless you pay cash for a farm, in which case, congratulations. But if it's heavily mortgaged or leveraged, and if something were to happen to me, would I be willing to sell that farm? And would that farm's value cover the outstanding debt? Or do I maybe need some term life insurance to boost that and take care of it? If I've got a retirement account with my job, is the easiest thing for me to do to designate a beneficiary to receive that, then boom, they have that account value right for them. It gets you thinking about that process. So I would just tell you, the most important thing you could do to get started is just pull that inventory together. And that really kind of shows you what those next steps are.
Thank you. Thank you.
Oh, you bet. Thank you. That's a great question.
Shannon, I have a question that somebody texted me. They said, if the land is in your husband's name only and he passes away, would the land come to the wife if she had a death certificate?
Ah, man, Sarah, the questions, you guys are phenomenal. So as any good lawyer and an economist, and since I'm a lawyer and an economist, I double up on this, would say it depends. But here's what it depends on. First off, in Oklahoma, we've got what we call the spousal election with estates, which basically means a surviving spouse has basically an entitlement to half of those marital assets and also the family homestead. So let's say, for example, the property that we're talking about is the family homestead. There's a pretty strong chance there that in that case, the spouse would have a claim to it under the spousal election, even if it was only titled in the husband's name. Now, if we're not talking about the homestead, but maybe it's just, let's say we've got a quarter section farm over here that was titled solely in husband's name. Then the next thing we have to ask ourselves is, did we buy that while we were married? Because the presumption in Oklahoma is that if we used marital assets, for example, the bank accounts that we have and acquired while we were married, to buy that, even if it's only titled in husband's name, it's presumptively joint property. Another thing is, what if great Aunt Betsy willed that property to husband and it was only in his name? Well, now that is entirely separate property. And so it gets treated like separate property under those default rules that we talked about there. So there might be a reason out there that property is held that way. Some people, for the purposes of the tax balancing, like JC was talking about in his presentation, might have said, hey, we want this to be completely regarded as being part of the husband's estate, and that's fine. I think that happens about 1% of the time. The other 99% of the time, we never thought about it, and it's just create title problems for us as we go through the administration of that estate. So, I mean, I have had property, and just in my own, me and my wife, if we have separately owned property, we have retitled it as joint tenants with the right of survivorship, because we are in zero danger of bumping up against any of the estate tax thresholds that JC outlined by a long shot. And it's a lot more important for us that there be no hiccups in terms of that title transferring when one of us passes away. My wife always assumes that I'm going to be the first one to die, which I resent just a little bit about that. That's why I'm on a treadmill desk right now, trying to exercise and lose some weight here. But all that to say, it may be worthwhile to say, hey, let's retitle that as joint tenants with the right of survivorship, just so there's no chance for something to go haywire with that title there. So the short answer to the question is, it might work out that the wife would have a claim to that asset, even if it is separately titled, but let's remove doubt if it's expedient for us to do that.
Okay, great. Are there other questions? We're going to see if there's other hands. All right. Well, if there are no questions, I'm going to stop the recording.